Good evening. Welcome to our presentation titled Estate Planning, Will and Trust. This is a part of our Many Matters series here at the Champaign Public Library. I'm Eva Liu, a reference librarian at the library. Thank you for joining us tonight. I would like to introduce our presenter for the evening, Roaa Al-Heeti. She is an attorney who concentrates her practice in the area of wills and trust, real estate laws, and immigration law. She earned her bachelor degree, master's degree, and JD all at University of Illinois. So she's from local. She became a member of Illinois Bar Association in 2007. She's a member of several organizations, including American Immigration Lawyers Association, the Executive Club, East Central Illinois Women Attorney Association, and Illinois State Bar Association, and Champaign County Bar Association. Roaa was named one of the 40 under 40 by Central Illinois Business magazines. She was the 2014 Global Mobility Immigration Award winner. Roaa, thank you for being with us here, and please help me to welcome her. Thank you.
Thank you. Well, thank you very much. I didn't realize we'd hit on such a hot topic, but apparently we have, and so I'm excited to see you all here. Look at this. All right, so there we are. That's my name, my firm, and where we are. Okay, this was, I promised you quirky because my personality is quirky, but this is a turkey getting estate planning just in time for Thanksgiving. Generally, what we're going to talk about today, I've hit sort of just broad topics is my goal for today. Hopefully get the wheels turning to allow for hopefully the next step, which is getting some of these steps actually taken care of. That's me. We've already been over that. All right, what is an estate plan? I'm going to start real basic. You know, this is a presentation to the general public. I want everyone to be on board with me. I even have former law professors who hire me for things like estate planning, and I say to them, you know a lot, but you're now on my turf. You're in School of Roaa. I want you to hear it my way. And so if I say things that feel too basic for you, I promise you it's not to be offensive. It's just to make sure we're all on exactly the same plane. So what is an estate plan? It's a very simple question, and I don't mean to overcomplicate it, but it's basically deciding what's going to happen to your things, what are your things, and who are the key people who are going to make sure that what you want to happen actually happens. Very broad, and we're going to talk about a lot of different things today, all right? So that's what an estate plan is. The follow-up question that I'll get from people is, well, I don't have an estate. So what is an estate? An estate is truly everything. I mean, it's whether it's little, whether it's big, it's 100% of what you own, right? Whatever that may be. And so that can include a home. It can include additional sources of real estate if you've got more than one property, but all of that real estate starting, and for most people, the house is one of their biggest assets. A bank account is part of your estate. Your retirement programs need to be considered carefully. It's not just a matter of who gets this thing that's on the table. No, your retirement programs are a major part of your estate and need to be considered. Any additional investments, stocks or bonds, would be part of your estate. Life insurance doesn't feel like it's part of your estate because you don't really cash out often unless it's a whole life policy until after you're gone. The IRS thinks it's part of your estate. They'll consider it when they want to decide whether to tax you or not. And so life insurance policies, whether whole life or term, are absolutely a part of your estate. And then your collections, whether it's a sentimental collection that doesn't have a lot of value, but you want to make sure it's in the right hands, or something that maybe isn't sentimental to you at all, but you know you're sitting on some serious money. But basically your things generally make up your estate. Oh, I went the wrong direction, didn't I? And Matthew's not here. I was instructed and I am not following instructions. Okay, here we go. So we've got little bubbles of the different categories we've mentioned. And then what are the goals? So why are we doing this? Why are we talking about estate planning? One of the first reasons does nothing to do with me, and that's making sure that you have enough stuff to keep you comfortable for life. Part of my estate planning, because it's comprehensive, includes asking you who are your other professionals. So if you're in my office, I'm already your lawyer. It doesn't have to be me. As long as you've got a trusted lawyer, that's a big part of your team. Your financial planner, your accountant. We consider that in my office a required triangle. We want to make sure all of those thoughts are filled. One of my primary goals when we talk about your estate planning isn't so much making sure that when you're dead, someone gets your stuff. Maybe I'm not supposed to say that as an estate planning lawyer, but one of my primary goals is to make sure you're good for life. So we're going to talk about that as part of your estate plan, all right? Who are the people that are going to take care of you? You want to be the one to decide who is going to take care of you when you're not well. You want to be the one to decide who takes care of everything when you're not here, and you want to be the one to decide who takes care of maybe little people or special needs people that are in your life. Who are those key people? So it's not just the things, but it's also the who. Who are the key players? And who better than you to know the dynamics of your family and who should do what? Better you than a judge. I'll hit on that in just a little bit more, but better you than a judge, okay? I like the judges, but they don't know your lives, and they know they don't know your lives. That's not an insult. Another thing people ask a lot about are avoiding taxes. Estate taxes are pretty steep. They can be easily a third of the estate. It's a lot. Most people, though, aren't subject to taxes. When we talk about the state of Illinois, we're looking for assets of $4 million or more. For folks who have, if it's like a married couple and they've earned a lot of retirement and they're looking at, at the age of 70 and pausing, there are a lot of people who stop and go, oh my gosh, we're close to that number. So it comes up in my practice more often than you would think, but I also get a lot of people who aren't anywhere close, and that's okay, but that's great. It means you're not paying taxes. Federal taxes kick in at $11 million if you're single or $22 million if you're married. And I always say, please develop a federal estate tax problem and come and see me. It's never happened, but these are the problems of people. I'm just going to go out on a limb and say, not generally us. So that's hopefully a relief that the tax question that I think lingers on so many people's minds, how do I make sure my heirs aren't paying taxes, really isn't applicable to a lot of people. But when it is, we do have tools and tricks to try to minimize those and make sure your family gets as much of the money as possible. Another topic that I'm personally very passionate about is making sure that you not only have a plan, but that the plan is simple to execute, okay? And so if I come up with an estate plan for you that takes your heirs 3 years to inherit and I make beaucoup dollars, we have not done a good job with your estate planning. For a good estate plan, not only do those people need to get the things, they need to get it easily, quickly, without much of a hassle. So we keep an eye on that as we go as well. There's obviously making sure it does eventually get to those people as one of our goals. For some folks, we want to think about creditors and how do we address the issue of making sure all of your debts get paid at the time you pass. And another one that doesn't come up on paper but matters in real life is I want to make sure that when you go, your family still likes each other after you're gone. So family harmony. And we've seen so many of those where it becomes an issue. You can only do so much, but let's do this so much and then walk away from it, okay? All right. Up. No, I still got it wrong. All right, what are our tools? And you know what, maybe I will actually go back because I want to tell you about them one by one. I want to first talk about powers of attorney. And powers of attorney is a term I'm sure you have heard about. I am more passionate than your average lawyer about powers of attorney. And the reason for that is I only go to court for two things. One is guardianship, and two is when my clients pass away, I administer their estate if needed. Guardianship of disabled adults, not guardianships of minor children. What that means is that for some reason, someone either at the age of 18, maybe they were born with a disability, and now they've turned 18 and mom and dad legally can't make decisions for them. And so we go to court and we put mom and dad back where they're supposed to be in making decisions for them. Or we have someone who maybe as they've aged have developed a disability and they need someone to make decisions for them. Because I do so much of this work, I understand it and I prefer to avoid it if possible for families. And a really easy way to avoid a judge being in your life for the rest of your life is to sit down with your lawyer for 15 minutes and sign powers of attorney. Well worth the investment. Does it always work? No, it doesn't. Let me tell you more about what a power of attorney is, but it does work most of the time. A power of attorney is you deciding as an able-bodied adult that someone else gets to make decisions for you. That's a big deal under the law. And they're actually more legally powerful than even a court-appointed guardian. Because you are deciding, even though you don't have to let anyone into your private life, you are choosing to do that. We have two kinds of powers of attorney: power of attorney for your estate, your finances, and power of attorney for your health. Would you like to be the one who decides who talks to the doctor if you're not doing well, or would you rather the judge pick someone out of a lineup of people in your family? But still, you want to be the one to decide. Same with the finances. Who do you know who's trustworthy, who will make sure that all of your expenses get paid? You need to be the one to decide that, not someone else. And if you plan properly with a power of attorney for health and a power of attorney for property, most of the time you get to avoid a judge being out of your life. Why am I saying most of your time? There are still times when I still have to take someone, even with an excellent estate plan, to court for a guardianship. And the one that's nearest to my heart that I think of often is a woman who I worked with for many years. She has a solid estate plan, but every single day she picks up the phone and calls her financial planner with a whole new set of instructions because she doesn't remember she called the day before. And so we needed to turn off her ability to make decisions. And we appointed as her guardian the person that she had listed in her power of attorney. So it was still her wish of who got to take care of her. But I needed more than someone to take care of her. I needed to have her declared disabled. We'll sometimes have where people are just giving away their money. We need to be able to legally stop that. And so we're still going to court. But we're appointing the people they want. With a power of attorney, most of the time, though, we get to avoid court. All right, so that's our first tool, really two: power of attorney for healthcare, power of attorney for property. I am more passionate than your average Joe, but I'm okay with that. I hope you are too. Here we go. A living will is another document that I think you've heard of a lot. People always think it's a will that takes effect during your life. No, a living will is you deciding that you do not want life-sustaining treatment. And that is a purely optional tool. It's not one that I push on people. If they want it, it's available. If they don't, then that's okay. But that's you deciding that if the doctor says you will not recover, you will not wake up, that you do not want to be kept alive, but you do want to be kept comfortable. In your power of attorney for healthcare, we ask this question as well. This is you really affirming it and saying, no, really, when it's time to go, let me go. And that's not for everybody, but if it's for you, then that's a tool we should consider. The next document is one that you've definitely heard of, and that's your will. Everyone's heard of a will. A will is, of course, a legal document. In the state of Illinois, it's got to be signed with 2 witnesses. Some states require 3, so that's a great idea, unless you've got a crystal ball that tells you where you're going to drop, but most of us don't. And a will, simply put, decides who's going to get your things and who is going to be in charge of making sure that actually happens. So a very standard will revoke any prior wills. It will define who your family is, and then it will decide who gets what of your things. It will name an executor. The executor is the person in our will who's in charge of making sure things happen. And then we tend to have language such as, please make sure all of my debts are paid, please make sure all of my expenses are paid. This is where if you have minor children where you're naming their guardian is in a will. If you have a disabled adult as a child, that's also where we're naming their guardians as well. Another thing I want you to remember about a will is a public document. When someone passes away, we have 30 days to record their will at the courthouse. And so it's not a good place to keep your deepest, darkest secrets, all right? For that reason, folks who are concerned about privacy will often talk about something called a pour-over will, which is a will that leaves everything to a trust. The trust is private. It stays in my office. No one has to see it, except as needed, which is not everyone in the world. But you could go to the courthouse and say, I'd like to see the will of so-and-so, and they would produce it, and you could look at that will if you wanted to. I expect as the world evolves that one day you can click, 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 and find somebody's will if you wanted to. Just a thought, right? Now, if you record it 35 days later, there's no will police that's coming after you, but generally we do try to respect that 30-day rule. How many more tools do I have? Oh, he's going to be so mad at me. I never got good at this. This is going on YouTube. Okay. All right. The next document I want to talk to you about is a trust. And the question I get quite often is, what is a trust? And it's hard to imagine because it is a piece of paper, but we very much conceptualize what it could be. And I'd heard this once from Susie Orman, and I thought it was a really great description. But I want you to think of a trust as a suitcase. So by creating this document, these pieces of paper that I draw up and you sign in front of a notary, we've created a suitcase. And during your life, you can put as much into the suitcase as you want. And as long as it's not irrevocable, we don't use those as much, you can take out whatever you want. So let's say I put my house in a trust. I can live in the house, enjoy the house is there for me. And then one day I decide I don't want to live in this house anymore. I want to live in a condo in Florida. Well, it's my trust. I just unpack the house and I use the money to buy whatever I want to buy. I can decide I want something in the trust or not, but it truly is a suitcase. And the goal, the end goal, is that everything will eventually be in the suitcase. And at the time you pass, slide that suitcase across the table and it goes to your heirs. Does that kind of make sense? Better than maybe what you've heard before? But during your life, you will be the trustee of your trust, and you can put in and take out what you want. And if you have one of these wills that I referred to as a pour-over will just a moment ago, a will that says, I leave everything to my trust, then when you die, instantly everything pours into the suitcase. We zip it up and we pass it across the table. And if you've got special rules like I want to give my children unequally, or I want to make a special gift to so-and-so, all of that gets to stay private. Woohoo. The other fun thing, and I should have mentioned this in the goals, as we talk about the ease of passing along assets, sometimes we try to avoid something called probate. And probate is the process through which your assets go to court to be administered. Okay, so it is a judge overseeing all of the assets and deciding, or not so much deciding, but overseeing it, and your executor is the one making the decisions. It's a decent process. It works for a lot of the times, but not always. It tends to add at a minimum 6 months, but in reality, a year or two to the distribution of your assets. And you pay people like me a lot of money to make it happen, which is not an ideal way to spend your money upon your death. If we can put a little bit more into your pre-death planning, we can often avoid probate. Well, what triggers probate? How do we avoid it? What does that mean? Probate is triggered by the ownership of any real estate in your own name and owning over $100,000 in assets, all of your assets, so even your retirement account. Well, gosh, Roa, we've met those requirements. What do we do now? We know ways around this. When I mentioned putting the house in the trust, putting the house in the suitcase, I've removed your house from the estate and I've already packed it up. It's not going to go to probate if it's already in the trust. We've got other ways of getting it in there. The state of Illinois has given us tricks like a transfer on death instruments, like naming a beneficiary on your house. These are all things to help keep real estate out of your name at the time that you pass away. Well, that's one way to avoid probate. Then on the 100,000, we can name beneficiaries, and that's a tool. I'm blending a little bit my tools just a tiny bit, but beneficiary designations are incredibly important. And when taken in consideration with a trust, they can be really, really powerful. So let's say you've got a retirement account and you name your spouse. Your spouse will get that asset, and no judge will get in the way and no creditor will get in the way. Now, I've had a client recently who was scared of estate planning. We couldn't do very much of it. We'd really tried, but it was an uphill battle. He passed away, and he had named his first wife as beneficiary of his retirement accounts. Well, he'd been married to his new wife for like 30 years, but it went to first wife. There's nothing you can do to stop it. You named a beneficiary, it is what it is. I've seen where folks have named children, but maybe not all of their children over time, and it only goes to the children you've named. And so they're incredibly powerful, but that's not something to be feared. That's something to be appreciated and used carefully. You get to give away an asset without anyone else getting in the way. So powerful. So name your trust as a beneficiary as an idea. And then whenever you want to make changes, come and see me privately in my office, or whoever your attorney is. Change that document as many times as you need to, as new grandbabies are born, or as your not-for-profit of choice changes, or whatever it's going to be. And meanwhile, your beneficiary designation stands. So we can mix some of these tools sometimes to have a really efficient plan, and look at that retirement account that if you had just written, people say this to me, oh, I just put my estate. Don't, it's more than 100,000, you're triggering probate for no reason. Who do you actually want it to go to? I also get folks who say, oh, I just named all my children, they'll get it equally. That works, but if heaven forbid one of your children predeceases you, Do you just want it to go to the living kids, or are you thinking you would have rather actually preferred it go to their children? We can do those things. We just have to proceed with caution. I'm not trying to scare anyone. I'm just trying to get the wheels going on what some of the options are as you consider how you want to proceed. A children's trust is also one that comes up in people's lives. You want to make sure the kids are accounted for, so we don't ever recommend giving big chunks of money. Sorry. We don't recommend giving big chunks of money to children, right? Or even sometimes 18-year-olds or 21-year-olds. We try to give that money over time, or we try to have someone look over it. So we want the kids to be looked after. We're going to name a trustee of our children's trust, someone who we know will take care of them. The joke I always make is you want to appoint the person that'll buy them the Toyota Camry, not the BMW, to get to college and back, right? You got to think these things through. But then at what age do they get it? That's a decision that you make, and we do that through the work of trusts, okay? We've talked about beneficiary designations, and we can name them on all kinds of things. Retirement accounts. I mentioned earlier the state of Illinois very recently, just in the last few years, have allowed us to name beneficiaries on our real estate through the transfer on death instruments. I love transfer on death instruments. They came out, I can't remember, it feels like 5 years ago, but don't quote me on that. That's just what it feels like. And what it means is that when I die, I want the real estate to automatically go to this person. And I'd set these up for people, and I remember the first time one of my clients passed away who had one of these, and my heart stopped thinking, oh gosh, I hope this works, it's new. It worked like a charm. It was so easy. I circulated a document amongst his children. They all signed it. They got the house, and they could do whatever they wanted with it. I didn't have to go to court. I didn't have to do anything difficult or tricky. They owned it, easy peasy. So that's a really new but pretty cool vehicle. It's a new tool that we get to use. Other things that we want to think about. So we've kind of gone through all of it. All right. To my loyal estate planning attorney, I leave my children a complicated series of trusts that will generate huge legal fees. This is what we're avoiding. All right, special considerations. I want you to think about the special people in your life who may need extra attention. So I mentioned children, but if you've got someone in your life with special needs, we need to talk about special needs trusts. How do we make sure that our loved one, maybe child most likely, but not necessarily, who maybe is on Medicaid or Social Security because they're not going to be able to work, if you leave them a gift of $50,000, it's beautiful. But you've just disqualified them from a lifetime of care, and your $50,000 is going to cover maybe one medical stay, right? We all know how expensive it is to get medical treatment. And so we need to find ways to be able to support the people who need it the most while not taking away the very basic resources that they depend on day in and day out. So special needs planning is certainly something we do quite a bit of. Special assets. I mentioned earlier the collection that's sentimental, but it could also be the family business or the family farm. In this area of the country, we do a lot of farm planning because people want to make sure the farm stays in the family, other considerations like that. And then charitable giving. It's an opportunity to do that if it's meaningful to you. Maybe a one-time gift to an organization that meant a lot to you, an organization that takes care of people similar to you, whatever it may be, but in your will or in your trust, we have an opportunity for charitable giving. Oh, and this is a kid wishing that, I think, Homer Simpson becomes his legal guardian. And then this is a kid requesting a $5 advance on her inheritance. What I do is rather dry, but I really enjoy it, so I try to bring you in on All right, so what if you don't have estate planning? I see this from time to time where people think they've done nothing to plan, when actually kind of on accident they've done some planning. So when you got that new job and they said, hey, your job comes with a life insurance policy, and you named someone, that was estate planning. You named a beneficiary. When you got the retirement account, whether it was on purpose with the financial planner or again maybe through work without realizing it, and you named a beneficiary, that's part of your estate plan. That's you deciding who's going to get something, right? Maybe you haven't put a lot of thought into it. Maybe it's very obvious. Well, obviously I'm going to name so-and-so. That obvious is meaningful, and maybe you've got a backup, and that's really important too. Sometimes though we name our minor children as beneficiaries, and we've now then triggered a whole new set of problems. People very often will name spouse, then all their minor children, because that's who they want to get it. But by naming all your minor children, you've now triggered a guardianship and court oversight and problems. So we've got better ways to do it, but at very least you've done some estate planning, maybe kind of on accident. Joint ownership is another one that's accidental estate planning. So I'll see folks who say, oh yeah, I just have so-and-so on my account because they take care of me. And well, do you want them to get it when you pass? Yes, I do. Well, then good. You've done some good estate planning, whether you meant to or not. Although sometimes what that looks like is people will name one of their 3 children on their bank account, not realizing then that one child has just inherited the entire amount, not a third of it. Cars in the state of Illinois, if owned jointly, if one person passes away, it goes to the other person. So again, where someone will name a parent for financing and the child or the parent passes, the other one gets it automatically. Joint ownership can be a car, but it very often is a house. We often go to real estate closings and we get joint ownership of our real estate. There are many different forms of joint ownership, so that's another thing to be conscious of. And I would recommend then, as we look at your estate plan, that we look at, even if you've got joint assets and we really do want that person to have it, that we actually look at the document, think about what kind of joint ownership we're talking about. Bank accounts, cars, houses. It can be a good tool, and I really wouldn't discourage the use of any available tool for estate planning. If a joint account makes sense and it's going to where you want it to go and avoids probate and does everything else for you, I just don't want you to think it's the only thing you might need, because then we haven't named an executor or made any special provisions if heaven forbid someone doesn't survive. The other thing that happens when you don't do your own estate planning is the state of Illinois does have an estate plan for you in the Probate Act. And so just to name a few different scenarios, I obviously don't know anyone's family background except for a couple people in this room, but if we were just to imagine, if a person is married and has no children, then all of their assets go to their spouse. If a person has children but no spouse, then all of their assets go to their children in shares of equal value, without taking into consideration the ages or needs of those children, something to be conscious of. If you have spouse and children, your spouse gets 50% of your estate, your children share the other 50% of your estate. That's the one that feels the least comfortable. It's not usually ever what anybody wants, but that's an option. If there's no kids, no spouse, then we're looking at siblings and parents to inherit. The other thing I worry about when we're doing the state of Illinois plan, the one size fits all, is have we done anything to avoid probate? I don't want your assets going to court. Usually, there are some exceptions, but typically that's not what we're looking for. You're not as actively involved in deciding who gets what. And remember earlier we talked about preserving family harmony as one of our goals. Leaving absolutely no plans or unclear plans is a way to make sure that harmony doesn't happen. When someone comes into my office and says, but Dad never would have wanted this, then I know we have a really expensive case ahead of us. Because once we start imagining what people who have died may or may not have wanted, and we're not agreeing about what that person who died may or may not have wanted, we are creating an avenue for a friction in the family that cannot be cured. There is no way to find out what Dad really would have wanted. It's over, folks. Your kids are not going to get along, maybe ever again. It's a really tough situation. So clear instructions are incredibly important for that family harmony. All right, how do we get started? I want you to not be intimidated by the process. Sometimes I feel like I have this conversation and people get scared away. Don't get scared away. The kinds of things we want to look at when we start thinking about your estate plan, we'll start with documents. I'd like to see the deed to your house. If you can't find it, we'll find it. But let's start by looking at deeds generally. Let's talk about looking at life insurance policies. Let's look at statements generally. Bank statements, retirement statements, start gathering those things. A lot of times when you meet with the attorney to go over what you want in your estate plan and they ask you details, you may not be quite so proficient in that language. If you've got the statements, your lawyer can generally figure it out. I want you to have a general understanding of your assets, but I don't want that to be such an intimidating thought that you never begin. Wherever you are is the time to begin planning and to start talking to someone about your estate plan. The other thing I want you to think about is identifying your personal goals. I've talked very generally about goals, but are there particular people in your life that you want to take care of, and how so? Do you want to take care of everybody the same, or do some of those people have different needs that we want to consider? Let's think about who can actually do this work for you. Who is the person that, if there's a medical crisis, should be talking to the doctor when we talk about a power of attorney for healthcare? That's not everybody. Who is the person who can keep your finances organized and make sure the bills get paid and that all the money is safe? Again, that's not everybody. Even if they're a good, honest person, it may not be the thing for them. So I want you to start thinking about who are the right people for some of these tasks. Do we have any assets that are particularly valuable that maybe need special attention? Consultation with an attorney I've mentioned a few times, and earlier I mentioned consulting with a financial planner or with an accountant. They're all pieces of the same pie. And then, of course, the next step is the creation of the documents, right? Whether you're doing it on your own somehow or working with someone else, we've got to get to that next step. Don't get stuck in thinking about your assets. But then get to the point where we're creating documents that really do implement your wishes. Review those documents, understand them, get them signed, and then implement the plan. If you've gone to all the trouble of creating a trust, for goodness sake, name your trust as beneficiary of your stuff so that things start to automatically fill that suitcase and I can slide it across the table when the time comes. Once you've got your estate plan, what do you do? Well, it feels really good. I don't know if you've done it before. Some of you probably have. It does feel like a big check on your list, and it's pretty rewarding to have done. And you can let it sit for a while, but I would say about every 3 to 5 years, pick it up and review it. Make sure it still says what you want it to say. You might be surprised who's still in your life and maybe who's not in your life for one reason or the other. Maybe the kids have grown up. Maybe you've moved on, maybe they've moved out. The birth of a loved one, the death of a loved one, those are all events that trigger an opportunity to revisit your estate planning documents. And then if your finances change, hopefully over time your finances grow, but who knows, maybe you have a major financial hit for some reason. Whether it's a growth or a decline, it's an opportunity to revisit your estate plan and make sure it does what you want it to do. That's generally what I have planned for today. I don't know how we're doing on time. Pretty okay. Does anyone have any questions for me? I've hit on so many things. Yeah.
As far as choosing executors go, you don't know anybody who's a good person for it, or all of your friends are older than you are, or you don't know. How do you pick one?
It can be tricky. So I'll have folks who will say, oh, I want to name my parents, but they're older than me. And your parents don't want to outlive you, but if that's really truly who you want, I say name them. And if they're not, but we have to have backups, okay? So make that list as long as you need it to be. Sometimes your financial planner or your lawyer can do it for you. Certain trust departments will do it for you, depending on the size of your estate. But another thing that I've suggested to people, because I work a lot, with all kinds of people, but sometimes I have immigrants that come in to see me and they're like, look, I have no family in America. And I'll say partner up with another family that doesn't have anybody and agree to do it for each other. And that's a plan that's been appealing to some people before too, is find, and whoever dies first wins, I guess, that round. But if you can kind of find people who maybe are in the same boat as you and agree to support each other in that role, maybe as power of attorney first and then as executor, that can be another way to do it. There are situations where people pass and they really have absolutely nobody. There is, and this isn't what I wish for you, but where we do have a public guardian who can serve when there's an estate that needs administering. Good question.
So I have a daughter who lives in England.
Yeah.
I've got 2 children who live in this country. But where my accounts are, I can't name my daughter in England as a beneficiary.
Oh.
Because she would have to be able to open an account in America so she can have the funds transferred to her.
Mm-hmm.
Would it be possible to have somebody from another country in a trust?
Mm-hmm.
Yeah.
So when we create a trust, we have the ability to create a tax ID number for a trust. It would be based on your tax ID number. I tend to hold off on creating them because I don't want the IRS to know about it until there's actual money to be spoken of. But in your situation, I think it would make sense to do that sooner. Another option is, if your daughter would be willing, it's kind of an annoying process to have a tax ID number created for her, but it does require her submitting her original passport. It's a whole process, but that is an idea. But you could set up your estate in such a way that it would go 1/3 to child 1, 1/3 to child 2, 1/3 to the estate, to the trust of child 3. And that would absolutely work because it's America. Trusts and corporations are people too, right? So we can create tax ID numbers for them. But we could think about creating one for your daughter as well.
Yeah. Okay, great, thanks.
I saw, yeah.
If we set up everything here in Illinois and then move out of state, do we have to start over in the new state that we move to?
I'm going to give you a very lawyerly answer. Maybe. So estate planning is determined by state law. And so it does vary from state to state. And so what we'll often recommend is if you move, is have a lawyer in your new state review your estate planning documents. And that's something I've done for people before. There's things in particular that we watch for, and if they're there, we say this is fine. And so that's what I would consider. But you're absolutely right. It is dependent on state law, and it may only be good for as long as you're in the state of Illinois. Your assets may only also be here while you're here, too. So it may make sense to restart after you move. All right. Yeah.
Okay, I'm an independent single person, and I'm thinking of setting up a beneficiary, being Amnesty International.
Uh-huh.
But now, I have a couple collections. Do you need to get a licensed appraiser to put a figure on your collections?
Oh, you said you have collections, like you collect things. I thought you meant like you
Like-
owed people money.
Like,
That kind of collections.
No,
I
no,
misunderstood
not
it.
that.
Okay.
No, I don't owe anybody
Anything.
which is a very great thing.
It is a great thing.
I owe them nothing. But no, I mean, I have a painting collection
Yeah.
and I have a rare book collection.
So you could get them appraised. Why are you worried about the value now?
Well, I don't know how you move things like that
Into a trust.
Yeah.
What we'll often do sometimes is when we create the trust, we'll create a schedule of things that we're moving into the trust. It's hard because there's no official label on it, right? And so those things, when you say in your will, in that pour over will, I leave everything to my trust, would be conveyed over. If you want to move them over during your life, we can try it by creating a schedule that we attach to your trust that says these are specific items that are being moved into my trust.
I want to move, when I die, I want all the value I have given to Amnesty International.
Yeah. I'm sure they'll find a way to make sure it happens too. Yeah.
I have the names and number to call.
Okay.
They probably arrange that, don't they?
I really do think so. I think they'll be happy to. And you'll name an executor in your estate planning. Won't you name an executor, someone who's in charge of making sure that the gift gets delivered?
Okay. You need to name an executive,
You do.
making sure that the property gets delivered to them.
Yep. And they're also going to make sure that you don't know anybody now, but sometimes we do just when we pass away for whatever reason. They'll make sure that all of those final bills get cleared, your final tax return gets filed, and then everything else gets donated.
Yeah, I'm approaching life in a no-debt status.
That's
and I will
fantastic.
keep it that way.
I like it.
I'm going for no debt ever.
Yeah. No, it's a great way to live. Sounds liberating more than anything else. Yeah. All right. I saw more hands, I thought. Okay. Yeah.
You had mentioned something about other states. Does that apply to, like, if you have land in another state, but your beneficiary is here?
Okay, so land in another state while you're in this state is tricky. So sometimes we may end up administering an estate in more than one state, and states approach your assets differently. State of Illinois we consider to be kind of grabby, where they, if they can find any attachment to you, they'll find a way to attach to you. With it being land out of state, I worry about even probate out of state in addition to maybe probate or estate administration here. So it happens, but you've got to address it pretty carefully.
So it doesn't matter if you have a beneficiary that you leave that to,
If you've got a beneficiary on that particular asset, it will transfer.
no matter if it's out of state.
Mm-hmm. And the transfer on death instrument is new to Illinois. I'm sure it exists other places, but I don't know that it exists everywhere. So we've got to be careful. But if you move it into the trust, we're good. Move it now while you're breathing. I think I saw you raise your hand.
I'm wondering about assets outside of the states, like all the states. Should we include it too, or should we have like a different?
It's tricky.
Like Canada, for example.
So yeah, so let's say you do have money in Canada, or whatever, some sort of asset in Canada. I would still be familiar with their rules there, and then I would at least mention it in my local will, what I would like done to it. What I worry about is, will the country of origin for that asset respect the will that you drew up in America? And so I would actually consult with someone in both places and plan accordingly for both places to divvy up your estate. Yeah.
This may be a little specific, but you suggested a trust, perhaps being a beneficiary or a pour-over.
Yeah.
So let's say you have an IRA. I actually ran into this with a family member.
Okay, yeah.
An IRA, a pre-tax amount of money.
Okay, so traditional IRA. Okay.
Right, deferred taxes.
Yeah.
At the time of death, so this person's beneficiary was their estate.
Okay.
So it went straight into the estate, and the same question would come up if it went straight into the trust, which you suggested. That automatically triggers paying
The tax.
income taxes on the entire amount that was in the IRA. If it went to individuals,
They could spread it out.
yes,
Yeah.
and take longer
Mm-hmm.
to pay those income taxes, multiple years instead of paying
All at
all
once.
today.
Yes.
So,
So those are very real considerations, and they are definitely things that we discuss in conjunction with the financial planner. So I know I keep leaning on my other professionals, the financial planner and the accountant, but you're absolutely right. There are tax considerations that we get to think about as we name beneficiaries and as we think about who gets what when, and that is one that we have to take into consideration. But with the tradition, so IRAs come in generally two varieties: a Roth IRA where you pay all the taxes up front, and then it's all this post-tax money that goes in, and so it comes out tax-free. Traditional IRA, you haven't paid the taxes when you put the money in, so when it comes out, you got to pay the tax. The taxes are waiting, beginning or end. And so if it all comes out as a lump sum, you pay all the taxes a lump sum. If it comes out over time, then the tax gets paid over time. And they'll set a number of years on how long you can take to withdraw the money. But that's absolutely right. And that's one of the things we have to talk about as we talk about one by one about your assets.
and human beings can take longer
Yes,
than a
trust.
or an estate. Those
You're-
are,
you're absolutely right. Yep. But I would still talk to the financial planner and make sure that we understand exactly what we're doing. And I will say that everything I've said is meant to be broad brush strokes. You've got to look at your stuff, right? And your assets and your people, your beneficiaries, and then make a plan that fits you. It's really not a one-size-fits-all, even with these tools. The tools are actually kind of the same, but it's still not a one-size-fits-all in how we apply them. No, that's great. I'm glad you brought that up.
Is there stuff like funeral planning that you can put into your will?
Yeah, so people like to put, Muslim people like to put funeral plans. I think probably people of the Jewish faith would be similar. People who kind of aren't the standard, right? The problem with the will is that we're not pulling it up usually until you're 6 feet under, right? It's not the first document we turn to when someone passes away. I'd rather see funeral planning and a power of attorney. So just today I met with a client who had prepaid for his cremation, and he knew exactly, he'd already decided on the agency and he'd paid for it. I had him put that in his power of attorney. I have folks that say, I want my ashes scattered so-and-so, or I've got folks who want to donate their body to science, and there's additional paperwork for that. That kind of stuff I'd put in a power of attorney for healthcare. That's what people are looking at when someone's not doing well. And it's a document folks will have easier access to. It's scanned into your medical file, and hopefully you've shared the document with your agent. The will, people do put planning in a will, but I just think it's too late. I don't know that anyone will see it in time to actually honor your wishes. Yeah, that's a great question too. Okay, yeah.
You mentioned listing somebody on a beneficiary and the transfer of death, like for a house. What's the difference between the two?
Okay, so beneficiary, that term, we use it for things like retirement planning and life insurance. A transfer on death instrument does the same thing, and so I kind of use them interchangeably, but they really accomplish the same thing. Upon your death, who does it go to? But in some contexts, we use the term beneficiary, and in some contexts, we use the term transfer on death. And so on real estate, we don't call that person a beneficiary. We call it a transfer on death instrument. But basically, the person you've named, it creates a beneficiary designation for them. I probably loosely use the terms interchangeably because that's how I think about it. But in some contexts, we can only name a beneficiary. In some contexts, we need this thing called a transfer on death instrument to accomplish that same goal.
So a transfer on death is more of the object and beneficiary is more of the person?
Transfer on death instrument, we're still naming a beneficiary, whether it's a person or a trust. Same with the beneficiary. So let's say on my retirement account, I'm going to pull that traditional IRA and use it for my story. So let's say I've got a traditional IRA, I put in $6,000 or $6,500 a year into it, it's got $30,000 on it. I'll name a beneficiary. Joe Smith gets this upon my passing. That person is my beneficiary. And then let's talk about my house. So I've got a house and I want to make sure that that house transfers to this specific person, and I know who it's going to go to. I don't want it to go through probate. I'm quite confident this is what I want to do. I will sign something that looks like a deed that's called a transfer on death instrument, where I will name Joe Smith and my house in the document. And when I die, the house will automatically transfer to Joe Smith. Does that make sense? Yeah. Okay, great. Happy to hear it. Yeah.
Where do you file these things? If you write a will based on something off the internet?
Yeah.
If you get two people to sign it, is it still good if it just sits in your house? Or?
Yeah. So we don't file a will until someone's passed away. So it's really only upon a person's death that we are filing a will. So while you're alive, keep it somewhere where people can find it, which, I'm going to throw this out there, maybe isn't your safe deposit box that no one but you can get into, although that's where we tend to keep these, maybe at least a copy and original somewhere where people can find it. But yeah, a will is a document that you sign in the presence of two witnesses, and that will legally suffice in the state of Illinois.
Does it matter who the witnesses are? Like, could a witness be an executor?
The witness can be an executor, but it should not be a beneficiary. And because I'm often named as the executor, I choose not to let me or I choose not to be a witness for these documents. I don't think it's a good idea for your executor to be your witness. It absolutely cannot be a beneficiary, though. And even I would avoid close family in general, even if you're not naming them. Go to the bank or the library and find two random people. The library, here we are. Yeah.
How much does it cost to set up
$1 million.
a will and also to do
A trust. So my answer to you is always it depends. It's two for two. I'm sorry. But it really does depend on the complexity. So if someone comes in with just a few things, maybe I think a simple will should be somewhere between $500 and $1,000, preferably closer to the $500 for something really straightforward. But then as it gets more complicated, $1,000, $2,000, maybe $3,000. It depends on what you've got. And when we do like the real complex farm estate planning, that can be several thousands of dollars. It really depends on what you've got and what you want done with it. It's not a fair answer, and I'm sorry, but you could call around and get estimates. I think almost anyone would give that to you over the phone. Yeah. Yes.
Isn't it true that you can actually, it used to be, and I'm not sure, that you could actually just create a will on your own with a will form?
There are forms, and the internet's full of them. Someone else mentioned it.
And you can then do it that way, and then you don't
incur any costs. So now we lawyers have opinions about such things. And the analogy we make is you wouldn't cure your disease with a WebMD diagnosis, right? But I can't say that it can't be done. It absolutely can be done. You just want to make sure that you understand what you're doing and that it accomplishes what you want it to. But I will not deny for a moment that there are not forms in the world that exist, and the internet is full of them. But I still think it's a better idea. And obviously I'm biased, but I think it comes from some ounce of experience as well.
I did my automobile accident myself too.
Oh gosh,
Yeah, I did.
that's a tough one.
It was easy.
Good. You sound like fun. All right. Yeah.
So there's an original for, let's say, a will.
Yes.
You make copies. What if the original can't be found? Do the copies mean anything at all?
They do. So what the probate act specifically says is that at the time someone dies, any will of theirs is to be filed with the courthouse. It doesn't say their last will. It doesn't say, it doesn't say, it just says any will. It's that general. And so let's say you create a will. I promise I'll get back to your answer. Let's say you create a will in 1995, and then in 2005, and then in 2015, and you keep all three of them. I now have to file all three wills at the time you pass away. I don't want to file all three wills. I would have much preferred that you had torn up the 1995 and the 2005 will, and now the 2015 will. I won't tear them up because that's actually a felony, but I wish you had.
And revoking them inside the will?
Right,
Doesn't
so
it do the same thing?
it does that legally, but I still have to file them. And if you named someone in 05 that you didn't name in 15, those people don't like each other anymore. So you should tear them up, and you should absolutely revoke. Now, if all we have is a copy, we still file it. It says any will, and if that's the latest one, sometimes it's all we have, right? So all we have is this copy. We file the will, and we'll typically include an affidavit from someone saying this is a true and accurate copy, and it's all we have. And then it's up to the court to decide if they agree or not. But the original is king. But life is also life, and sometimes we only have a copy. Yeah. I don't know how long I'm supposed to be talking, so I guess we'll just keep going until someone stops us.
So you mentioned having beneficiaries for like life insurance or like a 401k, and then it's distributed to the beneficiaries. But what about if you have outstanding debt, like your mortgage or car? Where does that money get pulled from?
Yeah, hopefully you've left some money somewhere that can be used for that purpose. But the creditors will look for money. If there's nothing in the estate, then sometimes we just have to say to creditors, there's nothing here, go away. And then it's a matter of how aggressive they are to try to figure it out. But it does pass outside of the estate automatically. They'll tend to grab onto whatever they can find, though. Yeah. Have we done it? Have we answered all the questions? Oh, one more.
So if you filed a will with a lawyer and now you need to change beneficiaries, can you just have two people acknowledge what you're doing, sign off on your copy, or do you have to go through the lawyer, or if you go through the lawyer, how does it,
So
is that like a second will, or?
it sounds, so you're imagining like an amendment that you would sign, is that what you're thinking of? I don't, yeah. I would go in and redo it. I just feel like you're creating a world in which there could be ambiguity, and ambiguity when you're not here to answer the questions sounds like a source of trouble.
Would that be a second will that would be?
Well, if it feels like just part of a will, right? And I don't like how that feels at all. And so I think my advice to you would just be have a new will drafted and make sure that the old one gets destroyed. I don't mean to be too harsh in my push, but I don't like the idea of an amendment existing as a standalone.
Two estate things within a year, so.
Oh gosh,
Experienced a lot of things.
yeah, you're burnt out. Yeah, exactly. So I think just get a brand new will. And there's a good chance your will said if so-and-so survives me, then they get this, and maybe you don't have to redo it, I don't know. But I wouldn't do this piecemeal thing. I think let's tear up all the old and start new and make it nice and clear. Yeah.
If you had your will done by a lawyer, does he have a copy of that too? I mean, if I changed it since that first time it was written, do I go get it back from him also, or just the one I have?
I would let them know to destroy it. If they hear of your passing, they read a lot of law firms do this, they just check the obituaries for clients because there's this legal obligation to file a will within 30 days. They'll file whatever they have, they'll file at the courthouse whatever they have in their physical files. So I would let them know to tear it up. I wouldn't count on the lawyer to have a copy. Don't let it be like, I'm not going to keep any copies, my lawyer has it. Because law firms close and lawyers die and anything could happen, I would definitely keep at very least a copy with you. But then if you decide you don't want that document anymore, let them know so they can destroy it. And no lawyer will be offended by that. It's, okay, great, thanks for letting us know. Or they'll tell you, come and get it, because they don't want to destroy your documents, and then you can destroy them. I think we probably have, you want to be our final?
Yeah. Does a transfer of death document work for bank accounts?
So bankers don't usually talk about this, but there is a ability to name a designation on your bank account so that it transfers automatically upon your passing. And I did this myself because I wanted to experience it and make sure my things were set up correctly. And it is very straightforward. No one mentions it when you open an account. Everyone does with life insurance, with retirement, but no one ever does with bank accounts. But it is absolutely an option. And it's so much better than joint, right? Because if it's joint, then they have access to your money. But this, while you're alive.
You still have like your power bill and stuff they need to pay, but they can't get the money to do that
until they've collected it. Yeah, it is tricky.
It's tricky.
And we want to leave enough money somewhere where it can pay all those things. Yeah.
So by doing that on your account, you go to the bank?
Mm-hmm. Yeah. I think I did it through DocuSign or something, but it was easy peasy. Well, oh, that's a great question. So it'd be great if your executor had a copy, if you work with a lawyer, your financial planner, and then somewhere easy to find in the house. If you're comfortable doing so, pass them out to the people named in your will and let them have a copy. Not everyone likes that. When folks come to see us for estate planning, we decide who's going to keep the original, us or the client. Powers of attorney, I make my clients keep, because I always say those emergencies only happen at 2 a.m. on a Saturday, right, where you can't find me easily. But then we make a packet for every single agent named in the power of attorney with a copy of the document, a set of instructions, and my business card. And that way, if something does happen, your agent has everything that they need. And with the holidays coming up, I always joke like, this will make great Christmas gifts or whatever. But dude, that's when everyone is together, is around these seasons. I've got where I'm power of attorney for very few people on earth, but like clients that I've worked with for a long time and they don't have anyone else in the world, I am their person. And I keep those in my car. So if I get a call like, hey, so-and-so's in the hospital, I'm good to go. I've got the documents I need. On the power of attorney for healthcare, definitely have the hospital scan it. But I will tell you from experience that when you need it, they will not find it in their system. It never, ever fails. So if you're someone that does, need to use their power of attorney for healthcare, keep it handy, keep it in the car, do whatever you got to do. Yeah. I worry about who has the power of attorney more than I worry about who has the will, but definitely if you're comfortable doing so, not every family is there. The more you distribute, the more open the conversation, the better for everybody. All right. Well, thank you so much. I'm very impressed by the level of interest, and I hope that I've helped in some way today. Thank you.